Major breaking and great news out of the state of New Jersey. Federal District Court Judge Renee Marie Bumb entered an order enjoining the vast majority of New Jersey's new concealed carry laws. We're going to have to break this down. It's going to take some time. There's a lot to it. Her opinion is about 240 pages long. And yes, I've read it. Let's talk about it. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new best-selling book, Disarmed: What the Ukraine War Teaches Americans About the Right to Bear Arms. Check that out. You don't want to miss it. A lot of lessons in there, and it's not that long of a book. All right, folks. Huge news out of New Jersey. As you may recall, there were two cases involving challenges under the Second Amendment to the laws enacted trying to restrict the carrying of guns outside the home in public for self-defense that New Jersey enacted after NYSERPA versus Bruin was decided in June of 2022 by the U.S. Supreme Court. Basically, New Jersey was one of those states, along with places like New York, that had a hissy fit and simply tried to thumb their nose at the Supreme Court. But as I predicted, most of these places are going to get spanked. And that is the case here because Judge Bumb did exactly that in a 240-page opinion, which I will link to down below, where she entered what is known as a preliminary injunction. A preliminary injunction, and just to jog your memory, a preliminary injunction is an injunction that prevents a party, in this case the state of New Jersey, and their agents, from being able to enforce certain gun control laws starting now, through the end of the lawsuit. That's what a preliminary injunction is. It basically gives someone preliminary relief that runs from the time the order is entered until, again, the end of that lawsuit, at which point a decision will be made by the judge as to whether or not a permanent injunction would be entered or not, and that occurs at the end of the case. But before you get to a permanent injunction, there is often the opportunity for preliminary injunctions for the duration of the case, and that was what Judge Bumb was deciding today in her 240-some-odd page decision, where she largely spanked the state of New Jersey over and over on some things that we're going to go over. It's very extensive, very well thought, very detailed and well-cited opinion here. Again, I will link to it down below if you want to read it yourself. It's long, but it's very well done. Again, things to remind you about before we get into the details here. There were two cases here. There was the Coons case and the Siegel case. The Coons case was a lawsuit brought by the Second Amendment Foundation and the Firearms Policy Coalition, represented by an attorney by the name of David Jensen. And then there was the Siegel case, represented by, and Siegel involved the Association of New Jersey Rifle and Pistol Clubs, run by Scott Bach with attorney Dan Schmutter. Those are the lawyers and the organizations, among others, that we should be applauding today and thanking them for their excellent service. There are other organizations involved as well. You can see them on the papers down below, which I've linked to. So I'm going to give you a quick summary here, and then we're going to get into the details. And this is going to be an extremely geeky video, but I think it will be very informative because we're really going to get into the details, and I'm going to flag some things, a lot of which, by the way, I'm happy to report you've heard out of here at the Four Boxes Diner, but it's always nice to see the views of the Four Boxes Diner become the law, as well it should, because I'm just following what the Supreme Court has taught us. Okay, to begin, much of the new concealed carry laws by New Jersey have been declared unconstitutional, but not all of them. And we're going to go through the ones that she declared, and again, this is all preliminary, right? She could still change her mind for good or bad or ugly. Judge Bumb concluded that much of these laws are unconstitutional. We're going to go through what she declared, tentatively at least, unconstitutional preliminarily, and then we're going to go over the things that she said either appear to be constitutional under the Second Amendment and NYSERPA versus Bruin, and a few things where she's like, I'm not sure yet. I need more information. So if I could summarize this 240-page opinion, the bottom line is, overall, extremely good day for the Second Amendment and gun rights owners, gun owners in New Jersey, especially those that want to carry guns outside the home in public. There are three areas where I would say we have to improve. Specifically, we have to work harder to win, and I think it's still doable. One is some of the claims that Judge Bumb refused to uphold in favor of the Second Amendment. She did so because of lack of standing, meaning she didn't think the plaintiffs had alleged enough or proved enough in terms of their standing vis-a-vis what they were trying to get in terms of a remedy. That can probably get cleaned up. The second thing is she said that on certain questions, like in terms of technical things like where does airport security begin and end, she said she needs some more factual information before she can make a final determination, and she instructed the parties to go out and get more factual information and bring it back to her when she deals with a permanent injunction situation, which will be many, many months down the road. And there were a couple instances where I think her analogies to sort of historical laws may not have been perfect, and she may have upheld certain gun control laws that I think in time we can clean up and knock out. In this case specifically, but I think overall she did a great job. I think it's a very well-reasoned opinion, and I don't see any compelling reason to think that the Third Circuit Court of Appeals will upset this. I also wonder whether or not the state of New Jersey will even take its shot and seek an emergency appeal to the Third Circuit to try to enjoin this. I think that might be a little risky on their part, because if they seek an emergency appeal to the Third Circuit Court of Appeals and it's denied, that's not going to improve their standing with Judge Bumb. But again, only time will tell. So that is the big picture summary. Now let's start breaking down what was at stake here. So to begin with, I just want to let you know that the table of contents alone was multiple pages long. This is just the table of contents of every section and all the different things that she talked about in this opinion. As you can see, these are all sections and pages of argument, and it goes on for pages. Again, this is just the table of contents. It's not even the substantive argument associated with what goes on here. Beyond that, let me tell you exactly what she's ordered, good, bad, and ugly, and then we're going to go through the analysis. Specifically, she entered a 4-page order that she then justified with her 240-page opinion. Again, the order is what you have to comply with. The opinion explains the rationale behind the order. So the order is about 4 pages long, but the opinion that justifies and explains why she entered the order she entered is about 240 pages long. So just to keep that in mind. Now, specifically, let me tell you what Judge Bumb ordered, and then we're going to do through the analysis. So the first thing she said was she grants the Second Amendment plaintiffs in request for a preliminary injunction on several grounds. Just to give you a quick example, she enjoined the sensitive places rules. As you know, sensitive places is a euphemism for government-mandated gun-free zones. She struck many of these down. Specifically, for example, she says that the state could not justify many of these quote-unquote sensitive places in the statute, so she struck them down with respect to carrying guns in zoos, in libraries, in museums, in bars and restaurants serving alcohol, also entertainment facilities. She also said that with respect to casinos, the law appears to be unconstitutional. She also struck him down in terms of public film sets. So if someone is filming a movie on the streets, that is not a gun-free zone under the preliminary injunction order. Again, you can see this down below and check it out for yourself, and make sure if you are in New Jersey, you consult with your counsel to make sure that your specific situation complies with law, because obviously I'm giving you a general approach here, but if you're in New Jersey, you want to make sure that you're doing everything right and don't run afoul of anything, because there's a lot to digest here, much more so than I can do in a YouTube video. But again, I'm giving you the overall gist of this. She also enjoined, meaning she prevents from being enforced, the prohibition on functional firearms in vehicles. She also said, this is a very huge one, she says that the government's enactment of a law that says that the default position is you cannot carry guns on private property, whether they're open for the public or not, is unconstitutional with respect to those parts of private property that are open for business or that are open to the public. So what she basically said, Judge Bumb did, is, again, with respect to the blanket law that says you can't bring a gun in a private home, for example, that is still enforceable. That wasn't even being argued here so much, so I'm not surprised that she said that. But she goes on to say that if it's a convenience store or store or anything like this, if basically they're silent, then the state of New Jersey can't come in and just say, yeah, you can't bring a gun into the store unless you get permission from the store owner. That default position, which is a new argument that the anti-gunners have been making the last couple of years, she said is unconstitutional. The state cannot enter that default and change it, and she goes into that in extreme detail. With respect to actually getting a license to carry and so forth, she knocked out and said it's likely unconstitutional to require that the police or the law enforcement agents that are determining whether or not to give you a license, it prevents them from going out and interviewing, at least part of the application process at the first instance, to going to talk to third-party people that have vouched for your character. So if you get a reference from a neighbor, they no longer have to interview the neighbor before they can give you the license. That is now enjoined. The in-person interview where you have to meet with the police or with the law enforcement agency, That is still the law in New Jersey. She did not declare that unconstitutional, but the interviews associated with third parties that have vouched for you, those interviews are presumptively unconstitutional and not enforceable under this preliminary injunction order. She also went on and struck down, this is big news, she said that the insurance mandate that says that before you can get a gun and carry a gun, you have to get insurance to do so. She declared that to be unconstitutional. Based on her preliminary injunction, she explains there's no historical basis for that and it's effectively a tax anyway. And she also again says that the prohibition on functional firearms in motor vehicles is unconstitutional. She talks about the Supreme Court as well there, and she says that again, you can't ban people from having functional firearms in their vehicles because that's just absurd and unconstitutional, and she declared that to be not enforceable under the Second Amendment. She does uphold certain sensitive places bans. She upholds them with respect to airports, but not for the purposes of dropping somebody on, or if you pick someone up at the airport and you drop them off at the airport in New Jersey, she basically says if you do that, that is acceptable. The state wasn't objecting to that. And also, if you're just bringing the gun in a locked container for the purposes of complying with TSA laws to fly your gun to another state, that also is acceptable. But she allowed the sensitive place ban on firearms at airports and at transportation hubs to remain in effect for the moment. One of the things about transportation hubs is she said even though the state didn't define it, for the moment she's going to allow that to remain in effect. I think that was one of those ones where she wasn't convinced that either party had supplied enough evidence on the point and is open to reconsidering the questions about airports and transportation hubs if the parties do more work in the area. That's one of the areas where she said enough work was not yet done. She also said that to the extent someone wants to bring a gun into a healthcare facility that provides addiction or mental health treatment or support services, the gun ban does stand. She did not declare that to be unconstitutional, but if you're going, according to this at least, to what she's calling an ambulatory or inpatient kind of an inpatient outpatient hospital, it's kind of funky the way it's defined, but basically what she says is it's like an ambulatory hospital facility. I don't know exactly what that means, but she says that the state could not just ban guns there. Of course, she says that any of these institutions could do it on their own initiative as the proprietor of a place, but that the government cannot do this through statute. Okay, so now we're going to get into the 240 some odd page. This is the opinion right here. Yes, I've read it, and now we're going to start digging in to it. And it's going to take some time, but again, if you don't want to watch this, you can read the opinion down below. I'll try to make this go as fast as I can. But to begin with, what Judge Bumb'S starts off with, she says that as soon as NYSERPA versus Bruin was decided, the legislature dropped the state's firearms law requiring a justifiable excuse to be able to carry the gun. And as we predicted on this channel, I said that the anti-gun states are going to try to declare everything a sensitive place, a gun-free zone, and that's exactly what they did. And Judge Bumb'S makes an observation that's exactly what New Jersey did here, that they went out and tried to declare all these things, quote-unquote, gun-free zone, sensitive places, even though she points out there's not a lot of history and tradition. Specifically, she says, when they enacted the laws, quote, the New Jersey legislature purported to abide by Bruin by declaring the nation's history and tradition supported banning firearms at those identified locations, period, close quote. And then, of course, she basically goes on to say that they didn't really do their job at all, notwithstanding that assertion. And I think that was obviously correct. Then she goes on to say that the plaintiffs, many of the plaintiffs who brought these lawsuits today, and Coons and Siegel, they had already been allowed to carry guns. She points out that one of them had been a victim, I think, of a kidnapping and was always allowed to carry guns everywhere the plaintiff went. And now all of a sudden, because of these sensitive place laws, people that were able to carry a gun in New Jersey all of a sudden could not carry guns in many parts of New Jersey that they could previously do so. That also speaks to whether or not these places are really, quote unquote, sensitive, given the fact that they've been perfectly fine to carry a gun if you had a license, for the entire history of New Jersey, and all of a sudden after NYSERPA versus Bruin, they're declared sensitive. I think Judge Bumb'S understood that was kind of an incredible statement and position by the state of New Jersey, and she wasn't buying it in most of these instances. And I think if you want to know exactly how unimpressed Judge Bumb'S was from the state of New Jersey, I think this statement here on page 3 tells you quite a bit. She says, quote, despite numerous opportunities afforded by this court to hold evidentiary hearings involving the presentation of evidence, the state, that's the state of New Jersey, called no witnesses. And despite assurances by the state, that's New Jersey, the state of New Jersey, that it would present sufficient historical evidence as required by Bruin to support each aspect of the new legislation, the state failed to do so, period, close quote. That's what she said. The state failed to do so. Specifically said, hey, they promised me you were going to come forth with all this evidence to show that all these laws were constitutional under Bruin, and they, quote unquote, failed to do so. Not my language, that's Judge Bumb'S. Obviously, New Jersey failed to impress in this. What's also interesting is she called BS, and I think she literally almost said it. She doesn't say it, of course, because she's a judge. But on page 3, footnote number 2, if you look at the first 2 sentences there, she literally calls BS on New Jersey. This is what Judge Bumb'S writes. Judge Bumb'S says in footnote 2, quote, the legislative record reveals the legislature paid little to no mind to Bruin and the law-abiding New Jerseyans' right to carry guns in public for self-defense. Again, the law's primary sponsor declared that, quote, because of Bruin, more New Jerseyans will die as a result of gun violence, period, close quote. She was not pleased by this because she understood what this meant, which is basically the state of New Jersey decided to thumb their nose at the Supreme Court and the Second Amendment, and she was having none of it. Footnote 2 proves that point. What's amazing is that Judge Bumb'S goes on and talks a lot about exactly what we discussed on this channel, that when you start talking about guns are good and bad, that is totally irrelevant to the Second Amendment. I repeat, guns good or bad, these arguments that the anti-gunners like to talk about in the mainstream press, what they can control, totally irrelevant to our Second Amendment rights, because we define our rights by text and history and not because some nut job somewhere might misuse a firearm. I don't lose my rights to free speech because some media outlet does something wrong and defames somebody. That's not how I lose my right to free speech. That's not my problem. That's their problem. If somebody misuses a firearm, I don't lose it. And that's exactly what Judge Bumb'S said here. So in her opinion on page 4, she says, quote, and this is again another attack and criticism by Judge Bumb'S on the state of New Jersey. She says, quote, instead of presenting the compelling historical evidence they promised, that's the state of New Jersey promised, the state of New Jersey and the legislature interveners have spent their resources writing a narrative that says, absent the court's indiscriminate approval of new legislation, the risk of dangerous and often fatal situation looms large. She goes on to say, it is this rhetoric that is not productive, particularly for this court's role here. This court is painfully aware of the gun violence that has plagued the nation. But what the state and the legislator interveners ignore and what their empirical evidence fails to address is that, and this is, you're going to love this, folks, is that this legislation is aimed primarily not at those who unlawfully possess firearms, but at law-abiding, responsible citizens who satisfy detailed background and training requirements and whom the state seeks to prevent from carrying a firearm in public for self-defense. Period, close quote. Judge Bumb'S has got it right. Again, we don't define rights by how they're misused, but we define them by text and history. And she points out that all these laws are trying to be enacted are indeed designed to harass law-abiding gun owners and not the criminal class. Why is that? Because guess what? Who's the famous philosopher that we talked about all the time here? I torture all of you with his name. I make you all learn this name. And now you're going to see why. Cesare Beccaria, the Italian Enlightenment philosopher, who the founding fathers looked to and read, who I'm happy to say, in the Pepperdine Law Review, wrote the definitive article on the importance of Cesare Beccaria, on his influence on the founding fathers when they drafted the Second Amendment, including Thomas Jefferson and John Adams. Guess what appears on page 5 of this opinion by Judge Bumb'S? A quote from Cesare Beccaria. That's right, folks. This is why you watch this channel, so you know things before even federal judges do when it comes to our Second Amendment rights. So here you have on page 5, Judge Bumb'S says, quote, our founding fathers were aware of the dangers such laws pose, meaning gun control laws. In his commonplace book, Thomas Jefferson quoted from Italian philosopher Cesare Beccaria's work on crime and punishment, where Beccaria discussed the false ideas of utility. And then she goes on to quote the famous thing that essentially says that criminals don't follow laws. And of course, as you know, it goes on to say that when you pass laws that disarm the law-abiding, you make them targets of evildoers because the evildoers don't follow the law and the law-abiding do, and they become more likely to be homicide victims. That is not an NRA slogan from the 21st century. No, that is Cesare Beccaria, who wrote this before the Constitution was even contemplated, and the founding fathers of the United States knew this. And of course, I will link to my Pepperdine Law Review article down below in case you're super geeky and want to read that history. But let's carry on. What Judge Bumb'S says about Beccaria is this. His words ring true then, they ring true today. Clearly, the state of New Jersey disagrees with Bruin, but it cannot disobey the Supreme Court by declaring most of New Jersey off limits for law-abiding citizens who have the constitutional right to armed self-defense, period, close quote. Again, powerful language from Judge Bum, relying on the Italian Enlightenment philosopher Cesare Beccaria, who in turn was highly influential on the founding fathers when they wrote the Constitution, including but not limited to the Second Amendment right to keep and bear arms. Judge Bum then goes on and lays out the overall theory, and then we're going to explain what she says about the overall theory of the Second Amendment, Usurper versus Bruin and Heller. Overall, she did a very good job here, and then we're going to explain how it applies to these specific laws in New Jersey, which she then applied. So to begin with, she sets forth, starting on page 14, I skip a lot of the discussion of this opinion involving standing. It's not worth getting into for you. It's not worth talking about standing and these kind of technical procedural details in this video. I just want to hit the highlights involving the substantive decisions involving the Second Amendment. For the purposes of this video, we can always go back if you feel the need. Now, substantive legal standard under Bruin for the Second Amendment. She goes on to say that in Bruin, the Supreme Court rejected the two-step approach adopted by many courts of appeals. Specifically, she said that the interest balancing test, remember what I've always taught you, this is very important. Tiers of scrutiny is very, 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 very bad. Tiers of scrutiny, interest balancing is very, very, very bad for the Second Amendment. We don't want any part of it. Anybody tells you otherwise, they're completely 1,000% wrong, or they don't like the Second Amendment. Do not kid yourself. And Judge Bum understands this here on page 14. She talks about how the Supreme Court in Heller and Bruin has rejected these interest balancing tests, because remember what these interest balancing tests do is they say, yes, we agree that gun control law violates the Second Amendment. We agree. But we get to balance that interest against the interest of the government in taking away your rights. And that interest balancing test is totally unacceptable for many reasons, including that government judges usually rule in favor of the government defendants to always find some public interest. So it's very bad for us. And the good news is Judge Bum says it's not applicable. It's not the law. She's not allowed to consider these public policy arguments ever again. The Supreme Court has made that clear. And she, as a quote-unquote inferior judge, must follow that. That's exactly what she did. And that's exactly what she said. And I applaud her for doing her job by applying the Supreme Court precedent is clear. She goes on to talk about the Supreme Court holding. She says that the Bruin decision made very clear that the, quote, the constitutional standard endorsed in Heller is still the law, and it's been made more explicit. Again, what I've always taught you is Heller sets forth the text, the history, and tradition test is not the Bruin test. That is not true. Heller, in 2008, set forth the proper methodology of understanding Second Amendment cases. The only thing that Bruin did is it elaborated on it, and it spanked lower courts for failing to follow Heller. So Heller is the law of the land. Bruin elaborates on it and spanks the lower court and basically teaches lower courts that refuse to follow the Heller methodology as little kindergartners and says, if you can't behave, if you don't know how to apply Heller, we're going to walk you through like you're literally 5 years old and teach you how to do it. Because for the last 10 years, you inferior courts have not been able to get this right. So we're going to literally walk you through with a sippy cup how to do it. And that is what Bruin is. Heller sets forth the law. Bruin takes that, elaborates on it, essentially providing lower courts with sippy cups to make sure they understand. Not all the lower courts got it wrong, but certainly plenty of them did got Heller wrong, and that's what Bruin was about. Bruin's about fixing the lower courts. It wasn't about adopting a new law, a new methodology. That's all fake news. That is not the case. And Judge Bum got it right here, because she goes on to say that, quote, the constitutional standard endorsed in Heller was made more explicit by Bruin. She says this on page 15, and then she goes on to say, and this is key, you all know how this works, quote, when the Second Amendment's plain text covers the individual's conduct, the Constitution presumptively protects that conduct, which means when in doubt, you throw it out, right? The presumption is on favor of freedom in the Second Amendment against the government. No different than when you go into a criminal court. The presumption of innocence is in your favor against the government that bears the burden of proof to show that you're a criminal. Again, this is what Judge Bum says, quoting the Supreme Court. The standard for applying the Second Amendment is as follows. When the Second Amendment's plain text covers the individual's conduct, the Constitution presumptively protects that conduct. The government must then justify its regulation by demonstrating that it is consistent with the nation's historical tradition. And it's not just any historical tradition. We're going to get to that. She does a great job drawing the distinction between actual historical laws as opposed to the musings of historians. Because remember, the anti-gunners want to talk. They want to bring all their historians in from these Ivy League schools and talk about the meaning of the Constitution and use that as a way to rewrite the Second Amendment. But here's Judge Bum is saying that is not the law that the Supreme Court set forth. You have to come forth with actual laws that were on the books at the time of the founding, that were were actually enforced, all this musings of the goals of history and the meaning of history doesn't count. And that's exactly what Judge Bumb'S said here on page 15. Then she goes on to say, specifically, and this is my point, she says, quote, the government must demonstrate that the regulation is consistent with this nation's historical tradition of firearm regulation. These are critically important words. You know this if you've been watching this channel. The nation's, quote, historical tradition of firearm regulation, period, close quote. That's the key, because the reference to firearm regulations is referring to actual laws, which means if someone comes out with some project that tries to redefine the Second Amendment as being this or that, or embracing slavery, or all this kind of sort of nonsensical academic theories, the Supreme Court says none of that matters. You need to come forth, government, with evidence of historical laws that were on the books. This is mission critical. And by the way, Judge Bumb'S uses this standard repeatedly because there were historians in this case that submitted expert reports and affidavits and things like this. And I don't want to say that, but amicus briefs and whatnot. Really, I think they were amicus briefs. And she basically says, hey, that's all nice historical interpretive stuff. But the reality is I'm a judge. All I care about is the actual laws on the books, which is actually 100% correct. And that is also very good for the Second Amendment movement, by the way, because you don't want academic professors redefining our rights and rewriting the Second Amendment. That's very, very bad for obvious reasons. We don't want that. The next thing that Judge Bumb'S does, she talks about pre-existing rights. She says the Second Amendment codifies a pre-existing right. It doesn't create a right. It codifies an existing right that existed before the Constitution. And then she points out that when the state comes forth with governmental laws, the burden of proof is on it to show that the how and why is analogous to what they're trying to control today. So, for example, back at the time of the founding, there were rules about how you stored gunpowder because that was highly flammable and you didn't want that to go up and burn down like the city of Boston, which was made of wood and stuff like that. So today, a gun control law dealing with, let's say, magazine capacity or whatnot would not be justified by virtue of the fact that at the time of the founding, you had black powder storage rules because the point of the black powder storage rules was about fire prevention, while today's concerns about quote-unquote large capacity magazines, which are just standard capacity magazines, that's about crime control or gun control, a totally different why those laws existed. And that's why the fire prevention law cannot be a historical, traditional basis of a regulation to justify a modern-day gun control law, because the why they existed are different, and that's what the Supreme Court has said, and Judge Bumb'S basically reiterated this basic proposition of law here. Okay, so let's start moving into the specific aspects of the New Jersey gun control laws that got knocked out and some that got upheld. First of all, let's turn to the permitting process and the application process to get these various permits, including the permit to carry. This is where she starts first. She starts off to say that again, obviously, putting restrictions on a person's right to carry a gun implicates the Second Amendment's text, and therefore it is up to the government to come forth with a historical tradition of gun control or gun regulations to justify it, and that is what she put the burden on the government here. Then what she does is she goes on to point out, and this is very interesting, she specifically flags the possibility that shall issue permitting regimes might be a problem, because she quotes Nyserpa versus Bruin, which talks about Heller and things like this, but she goes on to say, quote, Bruin left open the possibility of constitutional challenges to shall issue statutory laws because any permitting scheme can be put toward abusive ends. Now, she specifically says that means everything when it comes to these shall issue permitting laws has to be looked at anew in a case-by-case basis. So she flagged the possibility that New Jersey could enact a shall issue permitting regime, and it could indeed violate the Second Amendment. That was an open question. I thought that was quite interesting that she made that observation and very favorable to the Second Amendment. Then what's very interesting is she gets into why we have a permitting regime, and what she basically concludes, and she concludes correctly here, I'll sum this up quickly, is that the notion that the government can deny a dangerous person the ability to possess firearms, that is well established, but in doing so, she specifically rejects the anti-gun theory, right? We've talked about this, the Martha Stewart problem, which is why is it that Martha Stewart, who's never harmed a fly in her life, is not allowed to have a firearm because she was convicted of a quote-unquote felony of lying to the FBI or something along those lines, many years ago. And the government's argument has historically been that the Second Amendment allows the government to deny non-virtuous people. That's right, non-virtuous people, those that refuse to follow the law of the society in any respect. If they don't follow the law, they can take away their right to keep and bear arms. Our view, meaning the Second Amendment world's view, is that no, you can only take away guns if someone is deemed a danger to society. So if you're put in prison because you are a convicted murderer, you've been deemed a danger to society by virtue of that, and we can take away your gun rights in that instance. But if you have violated a recycling law or a trespass law or done some other administrative law, we've often talked about this, malum prohibitum, which are laws that get violated even though there's no moral component to it or dangerous component to it, that is not a basis for losing your Second Amendment rights. And Judge Bum agrees with us. She talks about the litigations going on, including the Brian Range case in the Third Circuit Court of Appeals, and basically indicated that her view is, given the Supreme Court's decision in Bruin, the touchstone is if someone is deemed a danger to society, a violent danger to society, you can deny them the right to have a firearm. But if they're just not virtuous or they violate some law, like a recycling statute or jaywalking, none of that counts. They have to be deemed dangerous. But she does understand that as part of the permitting process or the licensing process, she understands that process is really about making sure that the people that are able to carry guns are not dangerous. So she thought that as a general matter, in this instance, at least at facial level, it's perfectly fine. But she did open up the possibility that as applied, challenges to the shall issue permitting regime in New Jersey might be subject to challenge, and I think that's true. But for the moment, it's been upheld conceptually overall as okay under the Second Amendment for the moment. So specifically when it comes to the right to carry, this is the key distinction that you need to understand. She says it is perfectly fine in her view, at least there's no basis to say no for the moment, that the government can interview a person applying for these gun permits. So she did not strike down as unconstitutional in the short run for a preliminary injunction the obligation that you have to appear before the police officer or the person issuing the permit. However, she did strike down as likely unconstitutional the law that requires the law enforcement agent to actually have an interview of the people that are vouching for you, meaning that they're saying that you have good moral character. The requirement that the police officers or law enforcement agents meet with those people, that is declared as unconstitutional on a preliminary injunction basis by Judge Bum. So that's good news, at least in part. Then Judge Bum goes on to declare that the insurance mandate that says that for you to carry, you have to have insurance, that has been declared unconstitutional by Judge Bum. She said there's no historical precedent for that. She has many pages of this, starting really on page 70 to I think about page 90, discussing this in detail. And she specifically, as I've talked about before, remember there's these surety laws from the early 19th century that are outside of the founding period, so they're too late. And these are the laws that said that if your neighbor thinks that you're a danger, then you can go to court, have a trial, and if you're deemed to be a danger to society, then you have to post a bond. You don't lose your right to carry, you have to post a bond. I'm not even sure this has ever occurred in American history, but those laws are on the books. Judge Bum here talked about those laws, basically indicated they're too late and not persuasive and not analogous here to the insurance mandate, which says, again, you're not even allowed to exercise your right to carry a gun if you don't have the insurance. She said that is dramatically different than a situation where you're allowed to carry a gun, and then if someone worries about you, then they can make you post a bond after a trial. She says those two things are entirely disanalogous, and therefore the New Jersey mandate on insurance, having insurance in place to be able to carry, is unconstitutional under the Second Amendment on a preliminary injunction basis. Specifically, Judge Bum said the following, quote, "Firearm injuries have occurred throughout the nation since its founding, yet the state has not shown that earlier generations addressed this problem by mandating that all arm bearers obtain insurance or post a bond to prevent injuries that may not ever occur." Very close quote. That's page 88 of the decision. So again, the insurance mandate has been enjoined by Judge Bum as of now in New Jersey. Okay, I want to run through the sensitive places things real quickly. We can go into these in a lot more detail, but I know this is a long video. So bottom line is, she then, after talks about those rules and restrictions associated with the licensing process, she then turns to the quote-unquote sensitive places, which are government-mandated gun-free zones. She starts off with how to think about it. First of all, this is a very big win. She says specifically that just because the government owns property does does not mean they have the right to ban guns on the property. This is a very big win for us because one of the things that the state was arguing is that every single thing that is deemed state property is their property. And therefore, just as a property owner who owns a house can say, I don't want guns in my house, they get to say, I don't want guns on my state property. She rejected that basically as absurd. Obviously, if you think about it, if the government, which is bound by the Second Amendment and cannot violate the Second Amendment, can say that I don't want guns, for example, on my roads and highways that I pay for, well, you basically have destroyed the Second Amendment. She then goes on to point out, of course, that the Supreme Court has made it very clear, as did the Founding Fathers in the Second Amendment, that the right to keep and bear arms applies not just in the home, but outside the home, and outside the home means out and about in public. There is no specific locational restrictions to the right to keep and bear arms. That is not the case with other aspects of the Bill of Rights. So, for example, the Third Amendment, which we don't talk a lot about, but the Third Amendment to the Constitution talks about the quartering of troops in one's home. So when the Founding Fathers wanted to restrict a constitutional right to a physical geographical location, such as the home, they knew how to write it, which they did in, for example, the Third Amendment. But those sort of geographical locational restrictions are not present in the Second Amendment. Judge Bumb makes this observation and rejects the argument by the government that anything that they own, anything the state of New Jersey owns, they can just say no guns allowed. She rejects that outright, says that's not true. The next major thing that Judge Bumb decides is this is a very big deal. This is the default argument that the anti-gunners are really trying to trot out there over and over and over again. It's a new argument that they made, started a few years ago. This is the idea that they can pass a law that says that you have to get permission from a store owner, from a property owner before you can go on their property. And if you don't, you get to go to prison for like 5 years. Well, Judge Bumb basically declared this to be unconstitutional under the Second Amendment when it came to private property. Again, let me be very clear. When it came to private property that is open to the public. So, for example, if it's your apartment, if it's your home that's not open to the public, then yes, the default provision, at least for the moment, because it's not really being disputed in this case, as best I can tell, still is the law of New Jersey. But if you run a store, if you run anything that's open to the public about day-to-day life, you go into the grocery store, you're going to the pharmacy, any of these kinds of ideas, right? The idea is that the state passed a law that says these are private property or commercial property. You're not allowed to bring guns unless you get the permission of like the owner of the store or the owner of the building to be, even if it's a commercial location. You got to do all this stuff. You can't go to the law firm. You can't go to a doctor's, whatever it is. You got to get permission ahead of time, no matter how unpractical that is. Since half the time you're driving down a highway in New Jersey, you pull off to get gas. How do you even know how to ask? You have no idea. So again, the idea that the default position is no gun carriage, she rejected that. She said that is unconstitutional. Certainly people can continue to say no guns allowed and you can't come on with guns. That's allowed because that's your property if it's privately owned. But she says the default position is not allowed. And by the way, she does indeed say this is a state action because the state of New Jersey changed the default rules from you can carry a gun anywhere unless you're told not to the new law that was now been enjoined that says you're not allowed to carry guns anywhere unless you first get permission. So she said that flips the historical tradition of gun regulation on its head and declared that to be unconstitutional on a preliminary injunction basis. And that is basically pages 117 through about 135 or so. She gets into these details with a lot of good quotes and all this, and she distinguishes a lot of history. Now, in the context of this debate about the default rule, which again, the default rule is, are you presumptively allowed to bring guns on private property or presumptively not allowed to bring guns on private property? The anti-gunners want it to be you can't bring guns on private property without permission, express permission from the owner. The Second Amendment view, which is the right one, I think, is that you can carry a gun anywhere you want until someone tells you can't. That's how a free society works. A free society works is I can do anything I want unless I'm told not to. A totalitarian regime works in reverse. I'm not allowed to do anything unless I get permission from the government or somebody else. We live in a free society still. We don't live in a totalitarian society. So the default position New Jersey wanted is really totalitarian in nature and not allowed in a free society as I see it. But what's interesting here is on page 133. Yes, it's 240 pages. It's very exciting. We're on page 133 now. But Judge Bumb does something very important. Here she talks about a professor from Princeton University. It's a very pretty university, by the way. But a professor at Princeton University in history talking about some of the interpretations and applications of some of the laws that were being interpreted. But what's very important, this is the key, this is very big deal, folks, because we've talked about this important thing on the channel, which is you want to look to historical laws that are on the books. You don't want to get caught up in trusting historian opinions because historian opinions are not primary sources. They're not actual laws on the book, and they simply don't count. Maybe they're fun to read, but they don't actually count as a matter of law interpreting the Second Amendment. So that she makes this clear distinction. On page 134 of her opinion, she wrote, this is what Judge Bum writes. She says that this professor from Princeton, quote, his opinions appear to be based on his interpretation of the law, his interpretation of the law's theoretical application to such categories. But here's what's important. Then Judge Bum goes on to say, quote, the court is not presented with primary evidence is the actual laws, suggesting that the 1769 law and the 1771 law discussed below were enforced in, for instance, in businesses held open to the public. So you see how she's drawn that clear distinction on page 134, 133 between the theoretical thoughts and the musings of some professor on the one hand against actual laws on the books that judges are used to reading and finding on the other hand. This is extremely important. You do not want the anti-gun movement to use their professors to rewrite the law, to rewrite the history, and the Supreme Court was on top of this, and I'm happy to say we here at the Four Boxes Diner are on top of this too, and I'm letting you all know, watch out, don't be duped by this. Judge Bum was not duped, and I'm glad she wasn't. It's a clear rule of law here, but a lot of judges I can see being duped if they're not careful, because it's a little tricky area if you're not familiar with it. I also should note that she rejected the argument about the default position because she also points out that and we've talked about this on this channel as well, all the laws or almost all the laws cited by the anti-gunners of the state of New Jersey in this case dealt with hunting and poaching laws. So she made that observation. She also said that further evidence, this was about a poaching problem, is she says that if you violate some of these quote-unquote trespass laws at the time of the founding, the only penalty you would pay would be a small fine, presumably to offset the incursion or the poaching of an animal that you weren't allowed to take at the time of the founding. She said that is a stark contrast to the penalties that you would suffer if you take a gun into a grocery store under that default provision with a gun, where the state said you can't bring a gun into that store, and you do so because if you were to do that under the law, she points out, it's a potential prison term of 3 to 5 years and a presumptive sentence of 4 years. That is a far cry from a small monetary fine if you encroach on someone's property with a gun at the time of the founding, which again was really about hunting regulations and conservation efforts and anti-poaching efforts, having nothing to do again with gun control at the time of the founding. And again, this is what Judge Bum said, and I think it's wise. Then Judge Bum turns to public gatherings, demonstrations, and events requiring a government permit. This is a very big deal for the anti-gunners. You watch a lot of their writings. They're trying to argue that whenever there's people that are congregating, you can't bring firearms. Judge Bum rejected this. She said there is no history that supports this. She goes on to say that to place the state's historical evidence in context, the court reviews colonial firearm laws enacted before the Second Amendment's ratification. This is very important because what she says is correct, that because the Second Amendment's right to keep and bear arms codifies a pre-existing right that existed before 1791 when the Second Amendment went into effect, you have to look at what the laws were before 1791. You don't look at things like 100 years after the fact in the 19th century, which of course is an article I've written about, including in the Harvard Journal of Public Policy. I can put that down below if you care. But the point is, you can't look to understand the meaning of the words of the 1791 Second Amendment by looking at the words 100 years after the fact with a whole new group of people. What the heck would they know about what was the intent of 1791 except by going through the history books? So that is why you always have to look at the founding when you try to understand the Bill of Rights and the 1791 Second Amendment, because that's when it was enacted, and those are the people that intended something when they enacted, and those words had particular meaning to the people enacting it, and that is what guides us, not the musings of some person 100 years after the fact. And then this is important. Judge Bum goes on after making the observation about the colonial period is really the most important period for analyzing all this stuff. She goes on to talk about that many of these quote-unquote sensitive places at the time of the founding involved government provided for security. She says on page 167 of her opinion, quote, without considering the government provided security feature of the recognized sensitive places, the state of New Jersey would stretch the sensitive places doctrine to cover all places of public congregation. But then she goes on to say that is simply not permitted. That is not the law. Then she goes on to talk specifically about zoos. She points out there have been zoos in the United States for a long time and animals for a long time, and the state simply has not been able to come forth with any laws establishing a historical tradition of banning firearms at zoos, and therefore the laws dealing with you can't bring a gun to a zoo in New Jersey have been declared unconstitutional and enjoined. Then she goes on to talk about parks, beaches, recreation facilities, playgrounds, and state parks. Okay, now this is important to understand this distinction. This is very important, especially if we're led in these cases, because it's very interesting how Judge Bum blows up, for all intents and purposes, the New Jersey argument that you can't bring guns in parks, beaches, recreation facilities, playgrounds, and state parks. The only one of these that she upheld a ban on in this instance were the playgrounds, mostly because that involves children to some degree, but we're going to get to that in 1 second. She draw an analogy to schools. We'll get to that in a second. But specifically, the key is that the state of New Jersey brought forth a lot of laws talking about preventing or banning or prohibiting the discharge of firearms, right? You couldn't discharge guns in parks. You could not discharge guns in sort of public places. But that actually backfires on the anti-gunners. Just stick with me for 30 seconds. If you think about it, if you find historical laws at the time of the founding that say you cannot discharge, meaning you pull a trigger and go bang, a firearm in a public place, like in a city, in a common area, in a park, in a zoo, whatever it is, it actually works in our favor because it proves that guns were allowed in those places. You just could not discharge guns. Because why would you have a rule that says you cannot discharge a gun on Boston Commons if you weren't initially allowed to have a gun there in the first place? And that is what Judge Bum points out here. By the way, for those of you who may ask, I know there's some real geeks out there, but what about if I need to use the gun in self-defense? That's okay, because it's always been a basic black letter law of American life and English life that you can violate laws in self-defense. So, for example, you're not allowed to discharge a gun on Boston Common, but if someone's trying to murder you, you would be able to use a firearm and discharge the firearm to defend yourself in that instance, because that is something known as the doctrine of justification or the doctrine of necessity, which allows you to have an affirmative defense against a law like you can't discharge a firearm in Boston Commons, but then you use a gun to discharge to protect yourself. So that is fine, but bottom line is Judge Bum says that those discharge laws do not help the anti-gun movement. They do not help New Jersey. They only help the Second Amendment because they prove that you're actually allowed to have guns peaceably carrying those guns for self-defense. You just couldn't discharge them like for target shooting or whatnot, and I think that makes sense in many respects, doesn't it? So specifically what Judge Bum says, she says that the plaintiffs, meaning the Second Amendment plaintiffs, have established a reasonable likelihood of success on their Second Amendment challenge to the prohibition on handguns at parks, beaches, and recreation areas, as well as the state regulation banning handguns at state parks. However, this is the key. The court does say she's denying the motion for a preliminary injunction with respect to handgun bans at playgrounds. Again, Judge Bum, and this is something that I think will get cleaned up, she's drawn analogies in several instances to the fact that in Heller they reference schools as a sensitive place. I think that will get cleaned up over time, but because of that, she drew an analogy to say that things that are like schools, you can ban guns at, such as, for example, youth sports events, where she says, quote, "The parties have not persuaded this court to change its earlier ruling that youth sports events are like schools and therefore denies the request for a preliminary injunction." Do you see what she just did there? So when it comes to like things that are driven by children that are analogous to schools, robustly so, but I should warn you that she says specifically that just because children are at a location, just because there are kids there, doesn't make it sensitive, and you cannot ban guns just because of that. But if it's very similar to a school, like a youth sport event, she says that, yeah, a gun ban would be allowed if the state were to enact it. It would not violate the Second Amendment. She makes that point on pages 178 and 179. Then Judge Bum goes on to talk about public libraries and museums, where she declared this to be likely unconstitutional and enjoined them with a preliminary injunction. Again, she specifically says, this is important to understand, quote, "Again, the mere presence of children is not by itself enough to make certain locations like a school sensitive." You see what I'm saying? That's what she says on page 179. So just because there are kids around doesn't make it a sensitive place. It has to be much more like a school than just having kids. That's important. She said that, made that point. Then she talks, and this is key, she does talk a little bit about late 19th century laws in various points throughout this opinion, but she overall concludes that they're too late in time to count. This makes a lot of sense because we've talked about this on the channel. The famous case from 2020, an opinion by the Supreme Court by Justice John Roberts, the Chief Justice of the United States, where he rejected the fact that there were 30, that's 30. There were 30 states in the late 19th century that had passed laws restricting the use of public money to go to private schools and church schools and religious schools. 30 state laws in the late 19th century. And notwithstanding that, in 2020, Justice Roberts in the Supreme Court struck down those restrictions on First Amendment grounds. You see what just happened there? That the argument was that the First Amendment that prevents the establishment of religion in the First Amendment that allows for the free exercise of religion was violated because states in America today were banning the use of money from the government of those states to be used for like religious schools. And basically what the Supreme Court said is that violates the First Amendment. The government argued that no, there's a historical tradition in the late 19th century, 30 different states banned the use of public funds for religious schools, and that shows that it's consistent with the First Amendment. And Justice Roberts, and this is very important for our rights, and we've talked about this before, the First Amendment was enacted at the same time the Second Amendment was enacted in the year of our Lord 1791. So it was very good that Judge Bumb looked at the late 19th century laws and basically discarded them as not relevant, because that is correct and that is consistent with the Supreme Court's Espinoza case in 2020, written by Chief Justice John Roberts, rejecting 30 such laws is irrelevant to the meaning of the First Amendment right to free exercise of religion and the Establishment Clause, both of which were adopted at the exact same time as the Second Amendment's right to keep and bear arms. So let's continue on. So the Judge Bum said that the Second Amendment plaintiffs are thus likely to prevail on the merits of their Second Amendment challenge to the prohibition on handguns at public libraries and museums, and rightly so. Then she goes on and talks about bars and restaurants serving alcohol. This was another win for the Second Amendment home team. Specifically, she says that she's not allowed to consider policy arguments about guns and alcohol. She goes on to say that one of the big obvious problems of all these laws is that the issue is they're saying that if someone merely carries a gun peaceably and doesn't even have a drink in a place that serves alcohol, they're committing a major crime. And she says, obviously, that's just generally absurd because it doesn't draw a distinction between drinking alcohol and being in a place where alcohol is served. So again, Judge Bum said there's no tradition of banning guns in taverns, which makes a lot of sense since the American Revolution was largely plotted out in taverns at the time of the founding. So that would make a lot of sense. Then Judge Bum goes on to talk about the fact that there is no tradition of banning handguns in public on so-called film sets. Apparently in New Jersey, a lot of people are filming things like Law and Order on the streets out there, maybe in Hoboken or whatnot. And bottom line is, she says there's no tradition of banning handguns on public film sets, so she's not going to allow that law to be enforced because it violates the Second Amendment as she sees it. She also goes on to say, and this is a big one, that New Jersey was trying to say you could not have a working, functional firearm in motor vehicles, and she also declared that to be likely unconstitutional and enjoins that. What's very interesting here is you and I have talked a lot about this on this channel. Specifically, I've quoted repeatedly to you because very few people talk about this language from the Heller case in 2008. If you recall, part of what the law that was struck down in Heller in 2008 was a trigger lock law that required people to keep their guns locked up. Well, the Supreme Court struck that part of the trigger lock law down on the grounds that under the Second Amendment you had a right to a loaded firearm ready to go for self-defense, and if you are required to keep it locked and or unloaded, it's not ready in anticipation of self-defense, and that violates the Second Amendment. The good news is that Judge Bum essentially quotes the exact same language from Heller that I have talked about repeatedly on this language to try to get this language into the gestalt of the Second Amendment movement. So you all, again, are the smartest people in the room. Well, Judge Bum quotes this exact same language from Heller and goes on to say, quote, just like the law in Heller violated the Second Amendment, so too does this restriction on functional firearms in vehicles. To comply with this law, the carry permit holders must, in effect, render his or her handgun inoperable while traveling in a vehicle in New Jersey. Obviously, that is entirely inconsistent with a Heller ruling that says you have a right to have a handgun loaded and unlocked in anticipation of potential use for self-defense. Judge Bum could not agree more. And then she also points out that she actually talks about the fact that in New Jersey, you're more likely to have a problem where you need a gun outside of the home than inside the home because, among other things, she talks about how in New Jersey you have a large number of carjackings. From 2012 to 2016, she points out New Jersey reported over 1,300 carjacking incidents, obviously justifying, firearms. Again, you don't need to get into the public policy debate. Neither does Judge Bum, and she did not do so. She specifically says she doesn't have to do it, but she did make that observation that having a gun in the car is a good idea for self-defense. One interesting side note is that the Segal defendants actually brought an equal protection claim. Maybe this can be developed a little bit more, but essentially they said it was unfair for police officers, judges, and attorneys generals to be exempted from all these various gun laws, and ordinary Americans that are not in those jobs are, basically forced to suffer through the consequences of these burdens on their Second Amendment rights. Judge Bum rejected this equal protection clause argument. I think that can probably be built up, but at the end of the day, I suspect that our best chance to winning all these gun laws is under the Second Amendment and not the equal protection clause, but Yeoman's effort on that respect to try to make the argument. It certainly highlights the fact that New Jersey treats government employees differently than citizens that don't work for the government, which is not unusual for the anti-gun movement. Then, after talking about which parts of the law she thinks should be struck down as violative of the Second Amendment, she then goes on to analyze the rest of the preliminary injunction standards. As you know, to win a preliminary injunction, which means to enjoin a law, you need to establish certain things. The first is that you're likely to win on the merits, which is what that whole Second Amendment analysis was all about we just ran through. The second thing is that you, the plaintiff, will suffer irreparable harm, meaning that there's some damage that you'll suffer that you can't recover from. And then the last but not least, it's in the public interest to enjoin the various laws. The good news is Judge Bum agreed that we met, the Second Amendment movement, met a lot of these burdens. She said that obviously there's irreparable harm to the plaintiffs in many of these things because if they get it wrong, they go to prison. First of all, Judge Bum points out basic black letter law that says that depriving anybody even temporarily of their constitutional rights is by definition irreparable harm. So she did make that observation. So a single day of deprivation of your Second Amendment rights is irreparable harm. Then Judge Bum goes on to say, obviously going to jail is irreparable harm. She says specifically that the threat of criminal prosecution for engaging in constitutionally protected conduct certainly is irreparable harm. That's what Judge Bum says on page 221. So obviously the likelihood of success on the merits has mostly been established by Judge Bum. Then she goes and says irreparable harm the plaintiff will suffer if she doesn't enjoin these unconstitutional gun control laws. Then she goes on to talk, and this is very interesting, she actually spends time, even though she doesn't legally have to do so, she actually addresses some of these public policy, parade of horrible appeals to emotion arguments made by the interveners, specifically the New Jersey state legislators that supported these gun control laws. And she went through all the various public policy arguments / social science studies that say guns are bad for all intents and purposes, and she really distinguished them and said they were unpersuasive. And I think this is the most interesting thing that she said about this. She says, quote, the argument by the legislators can be summed up this way, quote, it is best summed up as an argument that all guns are bad guns. But this argument is problematic for several reasons. This is what she says on page 224. Judge Bum goes on to say that individuals may own firearms unrelated to self-defense, such as hunting or target shooting. Indeed, hunting and recreational uses like target shooting and plinking have long been the primary reason for gun ownership in the United States. Then she cites to a professor down at Duke Law School, I believe, for that proposition. Then she goes on to talk about the intervener legislators. Again, these are the anti-gun legislators that try to come into the case to try to justify the gun control laws. It did not go that well for them, as you can see. And then the next thing is she says, quote, these arguments ignore the fundamental right of self-defense, although the interveners from the New Jersey legislature cite to statistics involving gun violence. They do not cite to statistics involving law-abiding citizens with carry permits who use their firearms to save their lives, period, close quote. In other words, what she's saying is that the anti-gun politicians that intervened in this case talked all about how guns can be misused. But anything can be misused, including cars, trucks, baseball bats, and so on, and kitchen knives, right? We know this. Everyone knows this. And she makes this point to say, well, you're just talking about how people can misuse guns, but we don't measure or evaluate rights in America, including Second Amendment rights, by virtue of how they can be misused. We focus on how people use them properly and lawfully. And that is what the Supreme Court has taught, which is why in the Heller case, they laser focus on law-abiding Americans, lawful purposes for firearms by lawful Americans. That's why in Heller they focus on Americans using firearms for lawful purposes. They do not focus on misuse of firearms because that's not how we define constitutional rights. Some psycho misuses our Second Amendment rights. Doesn't mean that we lose our Second Amendment rights any more than if some media company or somebody else goes out there and defames someone or commits fraud by exercising the First Amendment rights. That doesn't mean that I have to pay the price because someone abused the privilege under the First Amendment to free speech. And last but not least, Judge Bum cites to Supreme Court Justice Sam Alito, where Justice Alito talks about how, yes, criminals are always going to get guns and gun control laws are really silly. This is what Justice Alito said in the Bruin case as a concurrence that Judge Bum quotes here, quote, no one apparently knows how many of the 400 million privately held guns are in the hands of criminals. But there can be little doubt that many muggers and rapists are armed and are undeterred by, in that case, the Sullivan Law, which is the New York carry permit. But again, Judge Bum says this because this makes a whole lot of sense. And then she goes on to talk about all the various studies that are basically anti-gun type studies and why they don't prove what they say they prove. She says that at the end of the opinion. And last but not least, Judge Bum relies on Cesar Beccaria and Thomas Jefferson. And in her conclusion, she acknowledges that no rights on, the usual general language that says, obviously there's certain regulations and stuff that may exist and so on to combat gun violence, blah, blah, blah. But basically what she says is that at the end of the day, New Jersey violated the thoughts of Thomas Jefferson and Cesar Beccaria. Specifically, it said that New Jersey's response, quote, went too far, becoming the kind of law that founding father Thomas Jefferson would have warned against, since it, quote, disarms only those who are not inclined or determined to commit crimes and worsen the plight of the assaulted, but improves those of the assailants. She quotes again Thomas Jefferson and indeed Cesar Beccaria, who you all must know, as I've been saying for like 2 years now. Okay, folks, I hope you learned a little bit something. I know this is a long video, but you wanted me to get geeky and break this down. It was 240 pages. I'll put the links to some of the key stuff down below so you can check it out. Again, if you haven't subscribed to the Four Boxes Diner, please do so. We'll see you again soon at the Four Boxes Diner.
Orders up. Table 2A.